on TV?
Yeah.
Wow. Good thing I'm not looking at it. I'd be scared. Well, nobody has a countdown.
So,
We got it? Okay. So we're good.
Yeah.
I don't dare start before the time. I wouldn't want to start without the people who arrive at the precise moment in time.
40 seconds.
You really are counting it down.
Yes. You got 30 seconds.
I'm just on time.
They're trying to pressure me.
Uh-oh. Oh,
I'm sure of it.
that's when you do your best.
Now I want you to hop up and down. Oh no, he's really doing it.
You're live.
We're live. Well, welcome. I'm Cathy Blackburn, and I really appreciate you being here this afternoon for this presentation on how does a will or trust work. I'm going to delay starting for a couple of minutes here and allow some more people to arrive and find a seat. And we are also streaming this, so there are people out there at computers and phones and iPads and maybe even televisions watching this. To me, it's magic. To these guys, it's what they do. So I appreciate everybody being here in person and on the live stream. People at home or the beach, please don't be driving down the interstate in your car while streaming this, but if you are stationary and choose to, you can comment on YouTube, and if you want to ask a question, you can do that as well. So as we go along, I will take questions from the live audience, and then I will repeat them for the people at home so that you know what someone asked. Do we have more people waiting to come in, Jim?
We do not.
Okay.
I will double check.
All right, thank you.
Two more.
Okay, very good. I very much appreciate the City of Gulfport making this theater available for us to do this. We were going to do this presentation in Scout Hall, where the house lights, of course, would be higher. However, it had no internet. So the large number of people who are watching us from home or wherever they are would not be here if we were in Scout Hall. So they kindly moved us over here where they could accommodate internet. Let me introduce some of the people that are helping here today. When you came in, Jim May was one of the people who greeted you, as was Skylar Chapman. They are folks that I call on to help me with these kinds of presentations, and their help is completely, essential, or I couldn't do these kinds of things. Over here in the corner, we have the masterful Tony Torres, the master of technology, who is responsible for setting up the entire live stream. So everybody type "Thank you, Tony" at home. And then Andrew Mays is in the corner, making sure that everybody on the live stream can see the PowerPoint without trying to read it on this screen. And then Steve Sadler is in the back managing the camera. So I can't do this without a whole team of people who do things I don't do, so thank you guys, I appreciate it. So we are here to talk about how does a will or trust work. And so I'm going to start with a will. Now, we did give you a little notebook. If you want to take some notes, you're more than welcome to do that. If you'd like to have a copy of this presentation later, all you need to do is let us know that, and we will email you a copy of this. But a will is your ticket to probate. Now, many people think that a will avoids probate. It does not. Unfortunately, or fortunately, the way that probate proceedings in court work is through a will and admission to probate court. So if you have a will and you think you're going to avoid probate, that won't happen just because you have a will. Come on, baby. Oh. So a trust. In general, a trust avoids probate court. Any kind of trust. What we're going to talk about here today is a special kind of trust, which is a revocable living trust, but a trust will avoid probate. A trust is a private document. It only goes to court if someone chooses to challenge it, which happens more often than one would like, but nonetheless not very often. So what's in a will? One thing that is in a will is probably what the ancient case law calls the natural objects of your bounty. This is basically your blood family. I don't know if you've noticed, but the nature of families has changed over the generations, and we have many kinds of families now that don't necessarily consist of a husband and a wife and 2 children. It used to be that we thought that was the only kind of family there was, and the laws were written a long time ago. So they refer to the natural objects of your bounty, which tends to include blood family, spouse, children, parents, nieces, nephews, siblings, etc. Now, of course, you're not required to leave assets to your blood family, nor are you required to leave them to all of your blood family. You can, in fact, pick and choose. Now, without a will, and sometimes people tell me, I don't have a will. And I say, well, you do have a will. It's just written by the state of Florida, and you might not like it. So there is a statute in Florida and every other state that says who will receive your assets if you do not do a will. In law, we call that the statute of intestacy, but it does list who gets them. Many people are afraid that if they do not do a will, the state will receive their assets. That's not really true. There are a very large number of people who will, in sequence, in order, receive your assets if you don't do a will. In Florida, it will go first to spouse if you have a spouse and your children are the children of you and your spouse. If it's a blended family and your spouse has children from another relationship or you have children from another relationship, it will go 50% to your spouse and 50% to your children. I'm probably saying too much here, but when things pass according to the statute, they pass in a way that is called per stirpes, which is Latin, and what it means is if you have any deceased children, their share will go to their children. So if you think about large families and you don't do a will, we're going to have pretty much of a mess when we go to do a probate proceeding. If you die without a will, we will need to do a probate proceeding in court to pass your assets. Now, I will tell you, I had one in which a lady had 4 children. One of them predeceased her. Her assets were going by beneficiary designation to the 4 children. And so then when another of her children died, we needed to probate both hers and the other sons. And the first son to die had 7 children with 3 different women. And a good number of them were minors. So this was quite the exercise. It lands up there with the person who left her assets to 13 beneficiaries, 4 of whom lived in Cuba during the embargo. So that was a challenge to figure out how to get pleadings and documents to people in Cuba. For me, who doesn't speak Spanish. So I will tell you that Google Translate works pretty well, and then I had a translator actually read it to make sure it was okay. But the moral of all this story is, please do a will. If you don't do anything else, please do a will. And in that, when you do a will, we avoid all these problems that we don't foresee, such as what happens if somebody predeceases us, what happens in divorces, what happens with all kinds of life circumstances, and you then are in control of what happens in those circumstances. So here's a tip. You can make a gift to anyone or anything that you like. You are not bound to leave things to your children, to blood family, nieces, nephews, etc. You can, of course, leave assets to them, but you can also include friends, neighbors, pets. You can take care of your pets. If you have pets, then we should include something in your will about your pets. If nothing else, we should indicate who should receive your pets. There are a large number of rescue organizations that step in when someone passes away without having made preparations for their pets, and I'm sure that you would prefer to make those preparations yourself, and so I encourage you to include that in your will. You can leave assets to your church, to charities, to schools, to virtually anyone or anything that you'd like. So more of what's in a will. It wants to communicate. I know it does. Okay. One thing that's in a will is your personal representative. We used to call that person the executor. In Florida, we have decided to use one generic term for the person who administers your will, and that's the personal representative. It's the same task as an executor and what we used to call an executor. And this person administers the will under court supervision. I'm trying to get this to move. Okay. And so they're the one that takes care of the process of probate, which is all court supervised. And they do that for the benefit of your beneficiaries and your creditors. So one of the requirements in probating a will or an estate of any sort is that your creditors will be paid if there are assets to pay the creditors. Now, they'll do that according to the powers that you give them within the will. and the powers that the state gives them through the probate statutes. So here's another tip. Make it easy for your personal representative. 2 personal representatives means 2 people have to sign a bunch of papers. Now, if you're selling property from within an estate, it means they have to sign even more papers. In my opinion, naming 3 or more people as a personal representative is unworkable. I know many people don't want to discriminate between their children. You think that it's their feelings will be hurt, or they will feel left out if you don't name everyone. I would encourage you not to name everyone. I would encourage you to pick the 1 person or the 2 people who are actually the best at managing details and paperwork. If you've ever done this, how many people have actually done this? Yeah. Was it an honor to do it? To be the personal representative of an estate? No, it was a lot of work, and it's confusing. So I would encourage you not to feel like it's an honor for people. Pick the person who is most tolerant of it and the best at it. So what else is in a will? Distributions to beneficiaries are in a will. That's the who, what, when, and how much goes to the beneficiaries. And it will go to them after expenses of administration and creditors. So, expenses of administration. The standard statutory attorney's fee in Florida for probate and a will is 3% of the value of the probate assets. Or if the value is low, many attorneys, and I'm one of them, charge a minimum fee. If you have $1 million estate, the attorney's fee will be 3% or $30,000 if you want to pass that through probate court. You can easily see when the value of probate assets starts climbing, the reason to do a trust goes up because a trust avoids this. The personal representative also receives 3% of the probate assets. So in $1 million estate, we're now at $60,000. And what I will tell you about that, which I'm really kidding, but I will tell you that if you want to pass your assets through probate, please bring them to me. I'll do a really good job for the $30,000 fee. The other thing that's going to come out of there are your creditors, including medical bills and any taxes that you may owe. Currently, we're not often in estate tax territory. The estate tax exemption is currently $11.7 million per person. Now, if you're over $11.7 million, you definitely need careful estate planning to minimize estate tax. But most people are not over that amount, and so you don't have to worry about the estate tax. However, here's the deal. Death and taxes are unavoidable, and you will still owe income tax for the period of the year before you pass away. If you want to avoid creditors, we need to do something else. Here's a tip about leaving your assets to individuals or even charities, etc. Use percentages instead of dollar amounts. Nobody knows unless you're psychic, in which case then you have a very large estate. If you're this good, but none of us know what the actual dollar amount of our estate is going to be when we pass away. So it's always much easier to say that particular individuals and charities receive certain percentages. then they'll still get something no matter what. I want to say something about Homestead. This is the bane of lawyers' existence in Florida. Homestead is governed by the Florida Constitution, Article 10, Section 4, if you care. But the fact is that what it does is it imposes a whole lot of restrictions on who you can leave the home that you live in to. Now, this homestead is different from the tax exemption homestead. The property tax exemption that you get for your homestead, where you have to apply for it, this is different. This applies whether you applied for the tax exemption or not. If you live in it and you own it, it's your homestead. If you're living in your homestead, you cannot disinherit your spouse. Your spouse gets at least a life estate, even if you haven't been together for 20 years. Even if your spouse has been in prison for the last 10 years. It's a bright line. If you are married, your spouse has a right to your homestead, and you cannot leave it to someone else. If you try to leave it to someone else, it will fail. And then it's going to pass according to the Florida Constitution. You also cannot abandon your minor children. In fact, you cannot devise your homestead at all if you have minor children. If you have minor children, that property will pass a life estate to your spouse, remainder to your children, per stirpes. So if one of them passes away, now we're going to have a big flow chart of everybody who gets tiny little pieces of your homestead. So if one of your children is deceased, you need to account for that. Chances are they didn't pass as a minor, having children of their own. Now, you can, if you own your home jointly with your spouse, that's fine. This doesn't apply. If you own the home jointly with your spouse and one person passes away, the joint owner owns it. However, if you own it yourself in your name and then you get married, you are subject to this. Now, the beauty of Homestead is that it is protected from creditors. You already know this, or you probably already know this, from living in it. Your creditors can't come and take your house from you. Now, the mortgage company can because you signed on the dotted line. But other than the mortgage company, credit cards can't take your house, medical bills cannot take your house, a car wreck cannot take your house. It's protected. If you leave that house to blood relatives, what we call heirs at law, if you leave it to them by title, it passes to them free of your creditors. So this piece of Homestead does avoid creditors. But they will get title to the house, and then they can do with it whatever they want to do with it. Do not, in fact, even if what you really plan is that the house will be sold and cash will be distributed to beneficiaries, that's always an option for your personal representative, but I always suggest do not demand it. Because again, you don't know if you're going to have creditors when you pass away. And if you do have creditors, you want to be able to pass this house free of them. And it's just as easy to give it to your beneficiaries by title and then let them sell it. If you force it to be sold, now it's cash and the creditors get paid. So that's probably the tip. I don't remember exactly. Whoa, 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 whoa. What happened here? Nope, I don't know how that went crazy. Sorry about that. I hope no one gets seasick while I click back here, because it went far, far ahead. My goodness. Maybe I had a finger seizure. I don't think so, but maybe. No, the computer's not hooked up, I gotta tell you. Yeah, the computer's separate. Now I know where I should be on the computer, but the projector is up there in the projection booth that's doing this, because it's tuned very nicely to this screen. So, you didn't make yours do that, did you, Andrew?
Sorry about it.
Okay, good. My. I apologize, but we don't have access to that computer that's running this except through this little mousey in my hand. And now I'm afraid of it, because it went crazy. Did you memorize that? Okay, good. Nope, this is a Homestead tip. When you're finished here today, there we go. When you're finished here today, you'll be able to draft a will, if you can actually assimilate all of this. So here's the tip on this. Don't try to devise your homestead on your own unless you're single with no children. You know, these online things will let you do it, but it could very well be wrong. So I would get legal advice before trying to devise your homestead, unless you're single with no minor children. So what else is in a will? Well, what should be in a will is this thing called a self-proving affidavit. This is something that's at the end of the will, and it recites certain formalities that are required for executing a will. It will have 2 witnesses and a separate notary. Without a self-proving affidavit, at least one person, one of the witnesses, will have to go to court to authenticate the will. So, the tip here on this one is make sure your will is self-proving, especially if it's old or from another state. So some lawyers don't do a self-proving affidavit. I do one on every will, or my staff would kill me if I made them go to court for every will. But we didn't used to do that. Certainly back in the 80s and early 90s, it wasn't as common. So if you have a will that's quite old, or you came from another state, go look at the last page and make sure that it is in fact self-proving. Most of the wills will say self-proving affidavit on it. So here's some final thoughts about a will. First one, where is yours? Because the original is required. If we can't find your original will, we have to prove what happened to it. Because the presumption in Florida is that if you do not have the original will, the testator, that's you who signed the will, tore it up. Because that's one way to revoke a will. So we're going to have to prove circumstances that would show you didn't tear it up. Okay, and don't put it in a safe deposit box. Everybody thinks they should put their will in a safe deposit box, except professional fiduciaries who beg me to tell people, don't put your will in a safe deposit box. Because if you're the only person on the box, when you die, we're going to have to get a court order to open it. And at that point, the only thing that can be done is that we inventory it with a bank representative, and then they will deposit the will in the probate court. You can't take anything else out of it. So the other thing, final thoughts on a will, if you already have one, you should make sure that it still carries out your wishes. And ask yourself, how hard is it going to be to administer it? Is one or more of your personal representatives deceased? Is one or more of your beneficiaries deceased? Now, ordinarily, and if I wrote it, it's going to say who will be the personal representative if your main person passes away. If I wrote it, it's going to say who receives that share of assets if a beneficiary passes away. So it doesn't invalidate your will. It's just that we're now going to have to prove to the probate court that that person is deceased, which means we're going to have to gather up a death certificate. And that can be easy or difficult. I confess not to be a NASCAR fan, but after the first NASCAR driver died at Daytona and all the press went and got the autopsy photographs and the death certificate, the legislature made those things confidential. So it's not as easy to get a death certificate as it used to be. They're now making a lot of things confidential. So that's in general about a will. So how is a trust different? This is my favorite analogy. Think of a trust like a filing cabinet. Now, I think that having a filing cabinet, just to have it, is a waste of money. It's not attractive furniture. So if you're not going to use it, then don't have it. And the same thing, I believe, is true of a trust. If you're not going to use it the way it's designed, then don't have it. There's no sense in it. So to use a filing cabinet, you have to label the drawers. You got to label the folders that you put in the drawers. You have to put the folders in the drawers. And we call that funding the trust. I've spent, before COVID, when we actually had networking meetings with people, financial planners in my face shaking their finger, "You lawyers, you never fund the trust." Except I do. In my office, if we create a trust for you, we will put together all the tasks that are necessary to fund the trust. It's not fun. Getting all kinds of change forms, changing titles of things, changing beneficiaries, doing deeds, recording deeds, all of that is not a lot of fun. And in my experience, when people do estate planning, it's hard enough to figure out what you want in it. And then you sign it all and you have a nice pretty notebook with all your documents in it, and you go home and you put it on the shelf and you go, "Phew, I'm so glad that's done." Except if you didn't fund your trust, it isn't done. So not funding your trust is like putting a filing cabinet empty in your living room. I don't think that's a very good idea. Nonetheless, if you use a filing cabinet the way it's designed, then everything you need to manage, you just go to the filing cabinet. It's very, very organized and it's very useful. So how else is a trust different? You can manage all kinds of assets within a trust. You can also manage them by joint ownership. So if you own a home and a vacation home and bank accounts and investment accounts and they're joint, when one owner dies, the other one will own it. And here's what I like to say to people: that's great for the first to die. But if life goes its ordinary way, we get older. Have you noticed? I've noticed. And if it goes its ordinary way, and you're married, or you have a partner and things are joint, in the distant future, one of you will pass away. And it will be the worst day for the survivor. And now you will have made no plans for where things go after the second of you passes away. So you have to think about that when you first set this up and decide whether you want to leave it just joint and hope for the best when the first of you passes away, or whether you want to make a comprehensive plan that takes care of everything after you're both gone. A trust will, of course, do that. Now, there are some things that don't belong in a trust. Oh, there. Your retirement accounts, your IRA, your 401k, your 403b, your qualified annuity, a trust cannot own that. And that has a tax-deferred status. So you want to be careful if you are naming a trust as the beneficiary of those things. We want to be very thoughtful about that. A business, I wouldn't have your trust own a business. You want to run your business. You're the one that's in charge of your business. Life insurance, ordinarily, except for some very special kinds of trusts, irrevocable life insurance trusts, and I'm not going to go into those guys. Usually a revocable living trust does not own your life insurance, and it does not own your annuities. You can name, and they can't be joint either. Now, a business could be joint. You can have certain life insurances, but it's unusual to be on joint lives. Annuities, same thing, but it's unusual. These things are going to pass to a beneficiary if you have one. Now, I didn't make a mistake when I put a business in here, because you can put a beneficiary on your business. It's not standard. If you create your own business on SunBiz, you will not get this. But there are ways to do that to make sure that someone will inherit your business. If you have a good advisor, they're going to make you put beneficiaries on your IRA, on your life insurance, on your annuity. Please put contingent beneficiaries. Don't just go with primary only. Pick people or charities or other institutions who are going to get it if your primary beneficiary predeceases you. Now, if these things, the things that can be joint, if they're not joint, they're going to go to probate. It's going to be testate if you have a will, intestate if you don't have a will, and you're going to pay those fees. These assets, if you do not have a beneficiary or your beneficiary is deceased, that's going to go to probate. You can name a trust as a beneficiary, but we have to talk about income taxes on those retirement type of items. Ordinarily, I suggest that you name human beings as beneficiaries of retirement accounts, unless there's a reason that they cannot manage it. If they're minors, we need to do something special. If they're incapacitated, we need to do something special. Now, to compare, how about a will versus a trust? So this is a little chart about typical life planning documents. By the way, I call what I do life planning. Many lawyers call this estate planning. To me, estate planning implies what happens to your assets after you've passed away. And that's important, and I certainly care about that. but I care every bit as much about how your life works for you while you're here, and especially if you are incapacitated, as I do what happens to your assets after you pass away. So I call it life planning. There are certain documents that apply only during your lifetime. Now, I'm not going to go into details about living wills or healthcare surrogates or powers of attorney, but those documents only apply while you are living. When you pass away, those are no good anymore. So don't think that you can take a power of attorney to a bank after someone is deceased and use it, because you can't. Assets in your individual name are going to be frozen upon your death unless they have a beneficiary. Now, your will applies only after your death and only after it is admitted to probate. And that then is going to distribute your assets to your beneficiaries, according to the will, through the probate court. Now, there are certain things that apply both during your lifetime and after your death. So that includes an vivos or living trust. That's the revocable trust that I've been talking about. It applies as soon as you set it up, and you manage it just like you manage it in your own name. It applies if you're incapacitated, and it applies after your death. Assets in joint names, same thing. Both joint owners can manage the asset. If one of them is incapacitated, the other owner can continue to manage it. If one of them dies, the other owner owns it. Assets with a beneficiary, you manage them as long as you're alive. And then when you pass away, they're distributed according to your beneficiary. Now, you could change assets that are in your individual name, and you could then put them in joint names. You also could put a beneficiary on them. You can do that with bank accounts. It's called pay on death. You can do it with investment accounts. It's called transfer on death. So almost anything, you can put a beneficiary on it. But these things are now going to pass outside probate court according to your documents, and they're going to then be distributed to your beneficiaries. Now, how do you manage a trust? So I said it's all very nicely organized in your filing cabinet. So the intention of the trust is to organize from within the trust. I like to say all roads lead to the trust. So you construct the trust agreement. Then you put everything in the trust. So you fund it. Once it's all in there, you can manage it there. Now, I think I made my point about you should fund your trust as soon as you set it up. Don't wait. Like I said, it's not fun, and you won't be eager to go back to do it. Right? Or anything to your trust. So that means that you can name the trust as a beneficiary. You can make bank accounts pay on death to your trust. You can make investment accounts transfer on death to your trust. I have a preference to actually title those things in the trust. If you want to know why, I will, you can send me an email or call me and I'll explain to you why I'd. But, so what else is in a trust? Same things as in your will. The natural objects of your bounty, just like in your will. Again, you are not limited to this. You can do anything you want to do. Name whatever you want in there. There is a grantor of the trust. That's the person who sets it up. So that's you or you plus someone else, ordinarily a spouse or a partner would be a joint trust. There is also one or more trustees in the trust. That's you, ordinarily, in a revocable living trust. You're the first trustee, or you plus your spouse or your partner. As long as you're alive and capable, you manage your revocable trust now, just as if it were in your own name. Nothing changes for tax purposes. It's still, if you have gains, it's taxed under your Social Security number. You keep managing until either you cannot manage it or you don't want to. And before I do the tip, I want to say something about that. I have a number of clients, and I'm really blessed that people feel free to call me up or email me to ask questions. So as my clients age and they think it's harder to manage their assets, I just met with a lady yesterday to do this. Then they want to bring their successor trustees on and make them a current trustee with them. So they're joint trustees. That way, if mom doesn't want to handle the investment account anymore, daughter can handle it. It's already set up that way. Some of my clients they get to a point where they don't want to manage these things at all, and so they resign as trustee, and then their successor trustee takes over management. So it's not just when you die that your successor trustee will come in and help. You have lots of flexibility there. You can bring them in before that if you want to. So here's the tip, this tip with the trust, and that is choose how you want to manage your assets. Do you want to have one account or a dozen different ones? You want to have a physical bank or do you want online banks? Do you want an investment advisor? Do you want a trust company or do you manage these things yourself? Well, what else is in a trust? Who's the beneficiary while you're alive? You want to guess? Yep, it's you. It's you or you plus. So if it's your individual trust and you have, for example, a disabled child, the beneficiary while you're living could be you plus your child. Because if you're incapacitated, your trustee is now going to manage it. If they only manage it for you, your disabled child gets cut out. And that can be true for a spouse or a partner as well. Because a trust is effective if you're incapacitated. If you're incapacitated, your successor trustee takes over and manages your assets. Again, from your filing cabinet, according to the terms of your trust and all for your benefit. You can make it differently, like I just mentioned, but ordinarily, while you're living, the trust is for your benefit. So, in my opinion, choosing a successor trustee to help you may be more important than distributing your assets after your death. Remember, I said I focus on life planning. Most of us are going to reach a time in our lives when we're not as sharp as we used to be. Some of us will reach a time in our lives. Some of us have spouses or partners who handle all of it. And if they pass away, we're lost. Some of us won't want to manage all of this. So you want to be very thoughtful about a successor trustee. Well, what else is in a trust? Yeah, payment to creditors. Here's the bad news. A revocable trust does not avoid creditors. You still have to pay your creditors. This is where we had that tip that you got a preview of. If you're concerned about creditors, You need advice specific to your circumstances. There are ways to avoid creditors, but a revocable trust is not one of them. What else is in a trust? Well, you have trustees. You want to be very careful about this. You're the first, then you have a successor, one or more. It can be family, it can be a friend, it can be a professional fiduciary. There are people who are professionals at managing this. Or it could be an institution, it could be a trust company. They can manage the trust will manage the trust assets immediately if the trust assets are in the trust. So if they're titled in the trustee manages them immediately. They'll be able, successor trustee will be able to step in soon if the trust is the beneficiary. That does not take a lot of time. The trustee will maintain your property. The trustee will pay your bills. The trustee can do your taxes. The trustee will distribute shares of your assets to beneficiaries, and they will do all of that outside court. So you do want to be careful with your trustee. You can require your trustee to have a bond. Your trust will pay for that. You don't have to do that. But if you're not certain that they're going to follow your wishes, then require a bond. That will protect it. So, well, I skipped over the tip pretty quickly. So my suggestion is make it easy for your successor trustees. Fund the trust fully during your lifetime. Give them all the necessary powers to take care of things, to sell your assets, to manage your digital accounts. On that topic, I'm beginning to have nightmares because so many people today, it started with a friend of mine who had some kind of a problem because every single one of her bills, all of them, is on auto pay. And she doesn't even know what they are or if they're being paid. So, when the mortgage company sold to a different mortgage company and they canceled her auto pay, the mortgage didn't get paid. And she didn't realize that until she got a letter that said, "Dear deadbeat, pay your mortgage." Okay? So I'm wondering how many more people are out there that do this. And if you think about it, when you're sharp, you know where these things are and you know how to handle them. But if you don't get any paper, if your banks don't send you statements, and they don't want to, have you noticed how hard it is to opt out of this, paperless stuff? I mean, they trick you into not getting paper. And if you don't get any paper and you know where it is, but nobody else does, and something happens to you, we're going to have some clues about how to find out where your assets are and how we're going to pay your bills. Now, sitting out there is this little booklet that I wrote, which is a financial and digital accounts log. And you can download this from my website also. So people watching from home, you can go to lifeplanlaw.com and you can download this. And what it does is it has lots of places. It has a few questions to jog your memory about where are your assets and where are your bills. But it's got places to record who's the provider, and if you're doing it online, what is your username and password? Help. You don't have to do it this way, but this is a way, and I wrote it out of my fear for what is going to happen here. If you are incapacitated and somebody has to help you or after you pass away, make it really easy for people if you write these things down. Obviously, don't publish it in the newspaper. Keep it secure. So what else is in a trust? Distributions to beneficiaries are in a trust. Those can be very flexible. You can keep distributions in trust after you pass. You can even make it so that the beneficiary is also the trustee. That way they get to manage the assets. Now you can give them something that will allow them to say who gets the asset after they pass away. That's called a power of appointment. Those used to be very, very common in both wills and trusts. I don't do them automatically. Nobody knows what they mean. And if you don't go to an estate or life planning lawyer that will actually read your old documents, you won't even know it's there. We don't use them as much anymore, but people often did that for children. You can leave things in trust with your beneficiary as the trustee so that they can use the assets as long as they're alive, but you say where they go after the beneficiary passes away. This I often use when we have a blended family where you want to keep the assets in your family, but you want to keep them available for somebody as long as they're living. We can do special trusts. We can do special trust for disabled beneficiaries so that they can keep their government benefits. We can do special trusts for qualified retirement plans if there's a reason that the beneficiary cannot manage that on his or her own. Now, interestingly, these same kinds of trusts can be included in a will. That's called a testamentary trust. But this trust only comes into existence after you have died and after the assets are probated. So if you do a testamentary trust, everything goes through probate and then it goes into this testamentary trust. Instead, trust has the same restrictions as a will. We don't get out of that. It's in the Constitution, we're stuck with it. And it's actually good provisions, you just have to know they're there. Come on. All right, what else is in a trust? The same self-proving affidavit will likely be in a trust. Now, make sure the trust agreement is executed properly. It requires 2 witnesses. If you do self-proving, it requires a separate notary. If you do this yourself and it comes from LegalZoom or Rocket Lawyer or something like that, don't think any of the blank lines are optional. Fill them all out. That will destroy your entire trust if it's not executed properly. So, thoughts on the trust. It can be amended or revoked. You can move assets in and out. You just change the titles or the beneficiary forms. So here's a little bit of a comparison chart between wills and trusts. A will is usually less expensive to draft. It is not effective until you die and it's admitted to probate. It has these expenses that I mentioned. You must pay your creditors. Usually, a will does not have testamentary trusts in it. Usually, assets are distributed outright to beneficiaries. It requires probate court proceedings. And it is easy to challenge. If this matters to you, if you have people that you think might challenge it, and you pass your assets by will, you are giving them the venue to challenge it. So once you admit the will to probate, all they have to do is write a letter to the judge, literally on notebook paper, and now you have a problem. So if you think somebody will challenge your will, it's not a bad idea to do a trust. They're harder. Trusts are usually more expensive to draft in the beginning. Not 3% of your assets expensive, but more expensive to draft. They're effective while you manage it. They're effective if you're incapacitated. To administer them when you're gone, it's less expensive, but you may need to pay professionals to assist. So you might need guidance from a lawyer, you might need guidance from an accountant. As I said, you still have to pay your creditors. You can have any number of provisions for beneficiaries, including special trusts. These are private, without court proceedings, and they are difficult to challenge. And the reason I say they're difficult to challenge is because if someone wants to challenge it, they have to bring the lawsuit. So the way that human nature is, people will, go to a lawyer. Oh, I've been so poorly treated by this trust. I must do something about it. Oh, yes, I agree with you. How terrible that they did this. We will definitely challenge this. It'll be a $10,000 retainer. How would you like to pay this today? And that's usually the end of it. Now, if there's a really valid claim, people are going to pay the expenses to bring the valid claim. But if it's nonsense, usually people won't put good money on nonsense. I actually cannot believe that I made it through this program in the time I said I would. This is my practice, lifeplanlaw.com. It's Blackburn Law Firm. We're on Central Avenue. There's my studio picture. And the names of the people who work with me. Colleen McIntosh is another lawyer that works with me. Kim Wilson and Sean Mullins Rothrock are legal assistants who know what is going on and can help. These are the things that we do. We do life planning. We work with LGBT community to do planning. We do elder law, probate, small business, asset protection, and some real estate. Within elder law, I do help people qualify for Medicaid in nursing homes. Do you want more information about these things? Feel free to visit the website, lifeplanlaw.com, and you can download that financial and digital accounts log, or you can download this life planning guide, which has some other information about typical life planning documents. If you have joined our email list and filled out the card here and you would like to have a PDF copy of this presentation, I'm happy to give that to you. Oh, well, that went away. Good grief. I don't know how that happened, but you can like us on Facebook. You can comment on the YouTube presentation. You can visit us at other seminars. If you have questions, you can email me personally at Cathy@lifeplanlaw.com, or you can schedule a complimentary consultation to talk about new life planning or about your existing life planning. And then, I'd be happy to help you, look at your particular circumstances. As I said, the first consultation is complimentary. So, thank you very much. I very much appreciate your being here. Does anybody have any questions? This was kind of like, drinking from a fire hose. Okay, I'm going to start over here. Ma'am?
I have a few, but the first one is if one already has a will, then the trust supersedes the will?
Excellent question. So for the people at home, the question is, if you already have a will, does the trust supersede the will? If you have a trust, you also have a will. That will is called a pour-over will. Pour over like a pitcher. So that if something ends up in your estate, it will then pour over to your trust. So when you create a trust, we do a new will, and it will revoke your old one. Sir?
At what value of your assets should you consider a trust over a will?
Excellent question. At what value should you consider a trust over a will? In the old days, when the estate tax exemption was $100,000 or $600,000, we often did trusts to avoid estate taxes. So trusts became associated with wealthy people. Now, if you have enough assets that you want to avoid that 3% probate fee, you should do a trust. And that's a lot less than $600,000. You know, at $100,000, the attorney's fee is $3,000, and the PR fee is $3,000. So you've got $6,000. I don't think I've charged $6,000 for the most complex trust I've ever done. So it is then cheaper to do the trust and avoid the probate fees. There are other reasons to do a trust that have nothing to do with how much money you have. One is ease and convenience. The thing I like best about trusts is how easy it is to manage assets if you are incapacitated. If you do not use a trust, we have to use your power of attorney. Powers of attorney are very difficult to use. Now, they will work, but institutions hate them. Some stranger comes walking in the door with a 12-page document and says, "Give me all of Mr. Smith's money." And the bank will say, "Oh, that is fascinating. Who are you and where is Mr. Smith?" And then misnomers within financial institutions about powers of attorney are just all over the place. I mean, the Florida statute says that you have to honor a copy, but most of the banks are going to demand the original. And they'll demand other things that they're not allowed to demand either. In the end, you will get there. You will be able to manage things with the power of attorney. It will just not be easy. And if it's one thing, it's one hassle. If it's 5 things, it's a lot of hassle. So with a trust, you don't have that. It's a seamless transition to a successor trustee. And so I think that that makes a big difference. If you have, for example, an investment account titled in a trust, as opposed to naming beneficiaries, some investment companies will liquidate all of your investments, take all the commissions, they'll liquidate it whether it's up or down, and then they'll distribute cash. They don't all do it that way, but some do, and that's adverse to you. So if you title it in the trust, that won't happen. Your successor trustee will step in. So there's efficiency and ease of use reasons for using a trust. Plus, it's completely changeable. Yes, sir.
I have a living trust from another state.
Mm-hmm.
Is it still good in Florida?
Super question. Is a living trust from another state valid in Florida? Answer yes.
I have a second part to that. We have not managed it for a good number of years. So we probably should have it updated. I have a 3-ring binder that's about that thick, and I can't remember the last time we opened it.
Ah, well, thank you for coming today. Now go home and look in there. Okay. Yes, ma'am.
Regarding the right of life, regarding the estate, what is common law in Florida as far as relationships go? Is there
No, forget it.
marriage here?
Out of the question. There is no common law marriage. Definitely not in Florida. I don't think there is anywhere. Yeah. You can duplicate virtually every asset of marriage with life plan documents. Yes, sir.
I'll follow up to that gentleman's question. Same here, original trust was made in Ohio in 1970.
Okay, you need to look at it. Your trust was done in Ohio in 1970? Yeah.
Updated in Florida in 1990. Can we update that trust and how often?
Well, It depends. So it was redone in Florida in 1990. When it was done in 1990, it was probably the estate tax saving trust, where you have a family trust and a marital trust. And given that the estate tax exemption is now $11.7 million, you probably don't need that, and you may have unintended consequences. So it should be reviewed. And the cost to revise it would just depend on what needs to be done. I mean, me personally, when somebody needs, like I said, the first consultation's complimentary, so it doesn't cost anything for me to look at it and tell you what I recommend. And then when I tell you what I recommend, I'll tell you what the flat rate price is to do it. When I'm amending people's documents, I recognize that you already paid, usually substantially, to do this in the first place. So I don't charge people to do amended documents, what I charge to do them from scratch.
Thank you.
Mm-hmm.
And how much is it if you do it from scratch, like if you've never had a living trust?
A trust, it depends. Ordinarily, I don't do just trust. I will do the healthcare documents, living will and healthcare surrogate, power of attorney. We always do a will. There's some ancillary documents you may want to do. So the cost of that is usually, and depending on the complexity, somewhere between $2,000 and $4,000. Yes, ma'am.
If you cannot put an annuity into a trust, what do you do with the annuity?
You name the trust as the beneficiary. Mm-hmm.
Then they do become part of the trust.
Well, then they are paid out to the trust. Some kinds of annuities you can put in your trust. I'm not sure it helps you. You remain the annuitant. So there's an owner of an annuity, there's an annuitant upon whose life the benefits depend, and then there's a beneficiary. Mm-hmm. Yes. Mm-hmm.
What is an irrevocable trust?
It's a trust that's irrevocable. I didn't say anything about it. So there are sometimes reasons to do irrevocable trusts, but they are what I just said, irrevocable. So you don't want to do them unless there's a good reason to do them. Yes. Did you have a question?
You just answered my question. I was going to ask you the difference between this and that.
Difference between a revocable and irrevocable trust, yes. Usually irrevocable trusts are done for specific reasons. Ordinarily, if you're doing a trust for your estate planning or your life planning, you do the revocable one. Any more questions? Yes, sir.
We're getting old and we don't know what we did with the trust. Do you advise us what to fund and how to fund our trust?
Yes. Even when I'm reviewing people's existing documents, I go over your assets and I find out if they are or are not in the trust. And if they're not in the trust, I always recommend putting them in the trust or directing them to the trust. Mm-hmm. Anything else? This is awesome. Thank you so much. You've been a great audience. Thank you, everyone at home. If you have questions, shoot them to me, Cathy@lifeplanlaw.com. Oh, we have questions on? Okay, we have questions from home.
Do you offer a package deal for people who have simple setups, car or house, no kids?
Yes. Do I offer a reduced price package for people who have a simple setup? Yes, I do. That is at a separate website. It's called mysimplelifeplan.com, and it's half the regular price, but it includes only a simple will, healthcare directives, and a power of attorney. mysimplelifeplan.com.
How can you plan for an incarcerated spouse?
Okay, we have to talk about how to plan for an incarcerated spouse because it depends on the circumstances. Okay, thank you. Thank you, people at home. Thank you, people in person. I appreciate it, and we are going to sign off now.